So, good early afternoon, everyone. My name is Lisa Thompson, and we are going to talk about single member LLCs and owning rental property and your best practices to limit personal liability. I've been practicing for almost 30 years. In October, it will be 30. I'm licensed in Arizona, California, Nevada, and Washington, D.C. And I write books for Thomson Reuters. So if you've done legal research, you may have seen some of the things that I have written. I handle all manner of business law, setup, maintenance, state law dissolution, compliance issues, businesses in financial distress, like anywhere in the life cycle of your business. And so that's what I love, and that's what we do at Thompson Law Group. If you need to reach us, our website is at the top, and our email address is contact@thompsonlawgroup.com. So here are my disclaimers. This presentation is not legal advice for your particular circumstance. It's for educational purposes only. There is no substitute whatsoever for getting your own advice from a qualified business attorney. All right, so here's my housekeeping. When I refer to companies, I'm talking about LLCs. And let's be very clear, an LLC is a limited liability company. And I find that a lot of my clients, even after they've listened to me, will say, oh, it's a limited liability corporation or a limited something else. It is a limited liability company, and it's really key that you know that, because it shows that you have a knowledge about your business, that you're getting the terminology correctly. I'm going to focus on LLCs owning rental property, but this presentation applies to all businesses, the general things that I talk about. And I will talk about general things, but hang with me. We will get to rental property specific topics. Mostly I will be focusing on single member LLCs or LLCs that are owned by a married couple. And for IRS purposes and our purposes, a single member LLC is either an LLC owned by one individual or an LLC owned by a married couple. And if the single member or the single individual is married, it's considered a single member LLC, whether or not your spouse is listed on your paperwork. We do live in a community property state, and the IRS treats it the same way as well. All right, so here's my best piece of advice for every business is get educated, and it will save you time and money, but also create a team, a professional team for your business. But keep in mind that everything is very location specific. So if you are reading something about owning real property in an LLC in New York, that is a very different thing than owning an LLC or owning a real property in an LLC in Arizona. Now, some things are federal, like taxation at the federal level is the same. But if you're talking about the formation of an LLC, or you're talking about how an LLC is going to be interpreted in a very, it's very, very state specific. And LLCs and corporations are creatures of state law. So it matters that you're in Arizona, or it matters that you are in California. And like, for example, in California, having an LLC is not normal. There are heavy duty taxes on LLC owners in California. So they are not as common as they are in Arizona. So again, just keep in mind when you're educating yourself, be very clear that you're getting information from real sources that are specific to your area, or read about other places. That's great. Just understand that they may not cover your business. So when I talk about having a team, you absolutely have to have a qualified business law attorney and a qualified tax professional. End of discussion, full stop. If you don't, it could be devastating for you. And I'm not sure which one is the chicken or the egg, which is my little graphic here. I'm not sure, talk to tax professional first, business law attorney second, or the reverse. If you come to me first, I'm going to say you need to go speak with a qualified tax professional because I do not have CPA after my name. I can tell you things that you should look for. I can tell you, the basic information about forms you will need to file, but I am not qualified to give you tax advice for you to rely on. And no attorney should be doing that unless they do have CPA after their name. Conversely, tax professionals should not be giving legal advice unless they have Esquire after their name. So you definitely want to get those two people on your team. And there may be other professionals that you want as well. And I keep using the term qualified, and I think it's really important, and we're going to talk more specifically about it in a minute, but get people that know and work in the area that you're having them give you advice. Like, you need to get, if you are dealing with rental property, you need an insurance person that deals with, insurance on real estate. If you have an intellectual property issue, you need to talk to an intellectual property attorney. All right. And you need to consult with your team. Just because you meet them and you have a relationship with them, you need to contact them on the regular, at least annually. And then also professional fees for the things that I'm talking about are tax deductible. So that's the added bonus. All right, and it's all interconnected. What I do affects your taxes, what your tax, how you handle things on your tax returns, affect have legal ramifications as well. So that's why I'm saying, I don't know if it's the chicken or the egg, but if you are doing a transaction, you need to check with the lawyer and check with your CPA. And I think it's even more important with rental property, and you will see that in a minute. All right. So you want to maximize your time and decrease your liability. And so I mentioned this because a lot of people are like, well, a lot of this I can do myself. And I want to save the time because I'm a new business, and I get it. I'm a business owner and I want to pinch my pennies as well. However, what I've learned is I am not qualified. Um, well, I could learn to do my own taxes. However, I probably would not do them well, and it would take me way more time than having someone else do it. And so I look at it as I need to be doing what I need to be doing, as far as, I need to be doing the things that bring money to my business. And I need to have professionals do the things that I am not qualified to do, or it doesn't make sense for me to do. So make sure that, again, you kind of look at it. And I bring this up because so many people are like, I can save money this way, and really not saving money, because ultimately I spend more time fixing things that people did on their own than if we would have just done it right at the beginning. And the other thing is, if there's a mistake, like if I make a mistake and I do my own taxes, I have no one to blame but myself. And I don't have any insurance to cover me, and I don't have anyone that can go defend me in the audit. If you do have qualified professionals and a mistake is made, you have some cover for that. And you also have someone else that's taking responsibility. So how do you find the right team? Um, Ask your friends, colleagues, and others in your industry. There's some generalities for what we do, but like, holding rental property in an LLC or having rentals is something that's very specific. So you want to get a tax professional who deals with that on the regular and knows the answers for you, off the top of their head. And if they have to look something up, they tell you, and that's fair enough. Do your homework as well, as I mentioned. You know, look up people on the internet. Check out and see, what others are saying about them. Kind of learn, what you can, but also get someone that you like. All right. So with professional fees, you should not be scared of contacting your tax professional or your legal professional based on fees. Have have a conversation about it. You can have limited fees and get the information you need. I'm not suggesting that you can't do some of this yourself. I'm just saying get some direction by someone that knows. And definitely, especially in my industry, there's a lot of my colleagues that do things hourly, which to me is terrifying. I had to hire an hourly attorney, and I was like, are you going to think about it in the shower? I'm really concerned about that. Um, but have a budget, say, look, I can afford X amount of time. And then your attorney will tell you if they can do that during that amount of time. Most attorneys are going towards flat fees. And my understanding from my CPA colleagues is it's the same for them. Sometimes there's a weird issue and you don't know how it's going to affect the business, and you have to do research. And so sometimes you are going to deal with hourly, but definitely get a budget. And if you look at using a third-party filer, which I'm going to talk about in a minute, just remember that that's just someone pushing paper, and they're not giving you legal advice. You'll get done what you want, but you're not getting anything for it. And at that point, I think you should really just do it yourself. All right. So this is my list of things to be asking your tax professional, and it's really important for folks that own rental property. So one, you need to determine how your LLC is going to be taxed. LLCs can be taxed any way that the owners want them to be taxed. They can be taxed under subchapter S of the Internal Revenue Service Code, which is what we call an S corp, or they can be taxed under subchapter C of the Internal Revenue Service Code, which is a C corp, can be taxed as partnership, or they can be treated as a disregarded entity. And a disregarded entity is just where the LLC, which is separate and distinct from the owners, is listed on a personal tax return. It does not file its own tax return. You also will hear this called flow through. And it's the same for partnerships as well. Partnerships are just when you have two people that are not married, that are operating a business as a disregarded entity. Um, you want to talk to your tax professional about avoiding self-employment tax. If you are only holding rental property, do you want to, I put Schedule C versus Schedule C. I just wrote this. It's Schedule C versus Schedule E. E as an egg. So Schedule C is typically where LLCs are listed if you're providing services. So if you're a real estate agent and you have an LLC, which should be a professional LLC, that's going to be listed in Schedule C. Versus if you have rental property, likely you are going to want to have that listed on Schedule E, because that's where you put royalties and any of your passive income. And the reason for that, and the reason why you want to have a conversation about that, is Schedule C can trigger self-employment tax. So if you're doing your taxes yourself and you haven't received any advice about this, you definitely want to go and talk to that tax professional. And my understanding is there's also various ways to depreciate the property, as well as there are different expenses you take given where you list your rental income and how you list that property. And the other big one that you need to ask is, how do you get money out of your LLC? Like, how do you make sure that you are pulling money out for you and your family appropriately? Is that by either wages, or is it by a draw? Or should you just hold the money in the account? You really want to ask your tax professional those things. All right, so I got it right here. Schedule C versus Schedule E. Again, Schedule C is more from services, and it could trigger self-employment tax. Schedule E is more passive income like rent, royalties. They both have different deductions, and they both have different depreciation schedules. All right, so here are the things that you want to ask your qualified business attorney. You want to make sure that you have all the protections in place that you can. And sometimes that requires disclaimers. Sometimes that requires a revamp of your structuring. Again, the second one is, how do I structure my LLC? You want to talk about what contracts and documentation you should have to further protect your business. What kind of succession plan would be appropriate for you? What formalities do you need to be following? And when does your attorney think that it's critical that you contact them? Like, what is the woo, 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 contact your attorney immediately kind of thing? And if your attorney can't handle something for you, like I said, they should refer you to someone else. The day and age of having, um, you know, one family attorney that handles everything is kind of over. You really need someone that's specialized in your area. All right, you definitely want to, I see this all the time, get someone to review your lease. It is completely cool to have one standard canned residential lease or commercial lease that you use. You need to have that reviewed every year. Documents from the internet are a great starting place. State specific is best. Um, I didn't do a search today, but before I give presentations like this, I like to Google what you can find. Um, Recently, and by recently in the law, that's like in the last 2 years, there is a requirement that there is mandatory bed bug language in every lease in the state of Arizona. And I only learned about that because I work in this industry and I have good friends that are landlord tenant attorneys. And they were like, hey, have you put in that bed bug language? And I thought, what? But no, it's a thing. You have to have language in your leases that say if that there is a requirement to report bed bugs, that you are going to do certain things about that. I would, for me, editing is way easier than creating. Absolutely go, create something that you like. You may have specific things that you want in your lease, and then have someone review it, and that's going to save you in fees. You want to be careful about canned documents and when they were created. If you were going to buy something on the internet, you want to make sure that it has been updated for the law. For example, in buy-sell agreements, the bulk transfer requirement in Arizona was eliminated over 10 years ago, probably more like 15 years ago. And I guarantee you, if you go and you search some canned agreements on the internet, like, I need a buy-sell agreement. I am selling the assets of my business. I am selling the stock or the ownership interest in my business. You will find a clause that says, this agreement is not subject to the bulk transfer laws of Arizona revised statute, blah, 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 which hasn't existed for 15 years. So again, grain of salt. All right, why should you form an LLC? So the main reason that you hear is that it protects you from personal liability. And the reason is, so it's like an umbrella. So you're under the umbrella because you're either the owner or the manager, and it protects you personally, right? It is a separate and distinct entity from you, just like a corporation. So whatever you know about corporations and how they protect, a corporation protects its owners and its officers and its directors. Same thing for LLCs, different terminology. A limited liability has its own EIN, which is just the business's social security number. It can sue and be sued. It can be dissolved or terminated without affecting its owners. So this shields you and your family and your personal stuff for any liability of the LLC. But that's only if you treat it as separate and apart from yourself. So how do you form an LLC? Well, the act of forming an LLC is super simple. There's no magic. You file articles of organization with the Corporation Commission. In Arizona, we call it the Arizona Corporation Commission. Once you file your articles of organization and they are approved by the Corporation Commission, then you need to publish them if you do not live in Pima or Maricopa counties, or your statutory agent is not in Pima or Maricopa counties. And after that, you are formed. There's no annual reporting requirements. And until you kill off your LLC, it's going to exist. What's more complicated about LLCs is how you operate it, structure it, and maintain it. And that's where you need to have help. So forming it, no big deal. You can absolutely do that. If you know how you need to structure it and you know what you want to do, then you doing it, we could all form like 10 LLCs right now if we all just got started on our computers. But would they be set up in an appropriate manner for what we need to do? So a lot of people will go to third-party filers, like I don't want to say names. Anyway, so companies that are like, we'll form your LLC for $2 or $99 or $299 or whatever it is they're going to do. Keep in mind that all they're doing is they're forming the LLC itself. They are not an attorney. They are not helping you with structure. You will have documents. I think one of the dangers, and if you want to do that, that's great. Just be educated about doing it. Understand that you are not getting legal advice. Will you have an LLC that's formed? Yes, absolutely. Will you have some of the things that you need? Yes, absolutely. But you want to be sure that you're not getting upsold on things. So a lot of times the third-party filers will automatically set themselves up as your statutory agent. And that is a recurring annual expense for them to be the entity that accepts your legal documents. You do not need that. If you want that, that's fine. But you do not need that. We're going to talk about statutory agents in a second. Many times the third party, once they form your LLC, you are locked out of being able to file anything with the Corporation Commission because it's a security feature. And so, and it can be unlocked, and I don't think that it's done intentionally, but trying to get it unlocked when you're dealing with a big company that does mass filings is very difficult. And then what it does is it prompts you to have to file things by mail or by fax, which is problematic. All right, so I'm just going to go through the basic terms of a limited liability company. I think it's really critical, especially when you're maintaining the corporate veil, that umbrella over you that is your LLC, to use the proper terminology. It doesn't matter if you don't like the terminology. You need to, on legal documents, use it, or there's really no reason to have a limited liability company. And again, keep in mind, this is Arizona specific, right? The terminology might be the same in another state, but not necessarily. It just so happens it's the same in all the states I work in. So members of an LLC are the owners. They own a membership percent interest. They do not own stock, right? And this is critical to understand, because when I hear someone talking about, well, I have an Arizona LLC and I have 50 shares of stock in it, I immediately have a thought about that. And I wonder, what other things does this business owner not know, right? Are they not, if they didn't take care enough to understand their own business entity, what else are they not, understanding, or they're not taking care with? So you really, I think it is critical, and especially if you're going to keep the corporate veil, to know the proper terminology. Ownership interests are like personal property. They act like stock, but you would say, like, I have a 50% membership interest in the LLC, and that's how you distinguish it. Managers run the day-to-day operations, and there's no president, vice president, secretary, or treasurer. They are managers. Now, if you want to, come up with some term and say, I'm the president of this LLC, I think you should go with the term CEO or CFO because those aren't really specific to a corporation or an LLC. That's just my opinion. But when you sign documents, if you are the manager of the LLC, you need to use that term. Members may be managers. A manager may be a third party. Um, you know, you can only have members, you can only have managers, or they could be both. There's no legal requirement to have an operating agreement, but it is really, really important to have one if you are not a married couple or a single member LLC with just one person. And I know it seems silly, like why would you need an operating agreement to govern the LLC when it's just you and your spouse or it's just you? But there are legal reasons to do it, and it's also a formality to show that you are treating your LLC separate and apart. As I said, there's no annual meetings or there's no annual requirements to report to the Corporation Commission. All right, members and managers are generally not responsible for LLC debt. That's by law. And I'm mentioning this now because it's going to go into how we look at owning rental property. So if an LLC is sued, the plaintiff, the person that's bringing the lawsuit, would only be able to go after the LLC's assets if they received a judgment. So say, for example, you have an LLC, the LLC owns rental property, someone slips and falls, the house burns down, whatever it is. The LLC is getting sued because it owns that property. It's the landlord. Okay, so if a judgment is gained, if there's an award made against the LLC, the only assets the plaintiff can go after are whatever's in the LLC's bank account and whatever the LLC owns, which generally is just that piece of property, the house and the dirt. And so that's something important to consider when we're talking about the analysis of what should be in an LLC. Insurance might cover your claims, but you really look at your worst case scenario, like what would happen if insurance didn't. All right, members and managers are always responsible for their own intentional acts. If you are operating as a reasonable member or owner and doing things that a reasonable manager would do to manage the LLC, then you're completely fine. However, if you stab someone with a pencil, you are not fine and you will be sued personally for that. Understand personal guarantees. It's kind of a little off topic, but I'm finding this more and more. One of the good things about having an LLC is that you can kill it off. If things go badly, if your idea for your business goes badly, you can shut it down. But if you signed a personal guarantee, you are personally responsible for it, for the debt of the business, that debt for the business. Now, based on the slide and based on what I'm saying, it sounds like you should never have a personal guarantee, ever, ever, ever. And that would be awesome. And that would be my advice. But it's not realistic because companies are just going to not give you any credit. They're not going to give you the copy machine that you need. If you buy a property in the name of your LLC, you're going to have to personally guarantee it, especially if you just formed an LLC. It has no history. So I mention this as a way of educating you. If you can avoid a personal guarantee, by all means, avoid it. If you can't, just understand that if the business fails, then you're going to have to pay for it. And you also keep in mind that Arizona, California, and Nevada are community property states. So in order for a personal guarantee to be valid in this state, both spouses, if you're married, need to have signed it. Again, keep in mind personal guarantees mean that you have to pay for the business debt if the business doesn't pay for it. And by all means, please keep those in a file. Because we have clients all the time that come in, the business has failed, and they're like, we don't have any personal guarantees. And then it turns out that they do, and that's a huge problem. All right, statutory agents. A statutory agent is the person that receives legal paperwork for your business. A statutory agent is required to, these are the requirements to be a statutory agent. You need to be over 18 and you need to breathe. And you need to be located in the state that the LLC was formed. That's it. It can be anyone and it can be you. So there's no reason to have an attorney or a service be your statutory agent. You do not have to do that. And I think that a lot of people think that they have to do that, and they do not. You can be your own statutory agent. Your CPA should not be your own or be your statutory agent. They're not set up to do that. If you are going to have someone else other than you be your statutory agent, you should use a service. There's a couple services in Arizona that are really inexpensive. It's like $49 for a year. And the good news is you can have various email addresses so that if you do get documents, which would be rare, multiple people would get information on that. So that is my best advice, is either do it yourself or be sure to get an actual service. You can have your attorney do it. But I've seen a lot in the last year where, I'll mention to my clients like, oh, such and such, they're your attorney. Why are you going to them? Oh, I haven't used them for years. And I'm like, well, they're your statutory agent. And they're like, what? My statutory agent? I don't even know what that is. All right. So protecting the corporate veil. You want to maintain any formalities that you can with LLCs. In Arizona, we have so few. Like, you file the documents and you publish them if you don't live in Maricopa or Pima counties, or your statutory agent isn't there. And that's it. That's the only thing required by law that you're supposed to do. So I think, and this is one of the reasons why I say, even with single member LLCs or LLCs that are owned by two spouses, is, do everything that you can to show that you treat it differently. So get your EIN number. Do not use your social security number, because you've got to show that this is separate and apart from you. If you use your social security number, you're just kind of mingling things together, right? Have a separate bank account. Don't commingle personal and business funds. Do not pay your personal expenses from your business account. Pay yourself first, or, pay your expenses first. And, for the business, the legitimate business expenses, then pay yourself, either by a draw or payroll, and then pay your personal expenses. Only use the LLC name for contracts. Don't use yours. So, like, for example, if your LLC was going to sign a lease for commercial building, the tenant needs to be the LLC. If you're going to be a landlord, the landlord is the LLC. You do not use your personal name unless you are signing as the manager. So it would be your name, manager of LLC name. Otherwise, you are not providing yourself the protection that you are trying to obtain. I think that this is my little explanation on how to kind of keep it straight, because I think that small business owners in particular have a really hard time, because it is just you, right? If you're a single member LLC or your two spouses, your business account is really your money and your personal account is really your money. Most of my clients are like, so I paid the whatever out of my business account. And you really shouldn't be doing that, because it shows that you're not keeping things separate. So I always like to say, okay, are you acting as an owner? Are you acting as the member? So if you're acting as the owner, you say to yourself, if you own stock in McDonald's or whatever big corporation, would your action be acceptable? So if you are a stockholder in McDonald's, could you go buy a yacht with business funds? The answer to that would be no, you could not. Are you acting as an employee? If you were an employee of McDonald's, would your action be acceptable? Would McDonald's allow you to pay your mortgage out of its business account? No. But if it's rental property, maybe you can, which is again where you need to talk to counsel or to your tax professional. And if you commingle your funds, then it looks like you're using your LLC as a plaything. And if you get a creditor that comes after you, they could go after that. Or they could say that the LLC is not a separate entity and they could come after you personally. So management structure is also key. And this is the biggest mistake that I see. So we talked about the umbrella covers you. The LLC is the umbrella. This is the veil, the corporate veil, the company veil, if you want. And so creditors, can't get through that so long as you've kept the formalities very clear that you're separate. However, you personally have ownership in that company, and creditors can come under the umbrella and they can take that ownership interest in the LLC. So if you personally got in a car accident, if you personally did something that was wrong, and you had creditors coming after you personally, they can take your personal things. One of those personal things is your ownership interest in your LLC. And that includes a bankruptcy trustee, that includes anybody that has to collect from you personally. Now, you can avoid that if you make your LLC manager managed. So there's two ways for LLCs to be managed. One is manager managed and one is member managed. The lazy way to form your LLC is just say, yes, it's member managed. I'm the member, I'm the manager, I am member managed. What you want to do is you want to say, I am manager managed. Lisa is the member, but Lisa is also the manager. You want to list those two things. And then you want to have an operating agreement that says that members make no financial decisions in the business at all. None, zero. Only the managers make the decisions and they have the sole discretion to do so. And what that means is if someone comes and takes this interest, that's fine. They can be an owner of the LLC, but they make no financial decisions. And so you can effectively freeze them out. They'll get a K-1 at the end of the year, and they have to pay taxes on either the profits or the losses that they get, but they cannot manage the business, which means they cannot sell the property and they cannot do anything that would harm the operations of the business. They can't shut it down. And the way that you, the manager, would be able to get money out of it is because you have an operating agreement and because your manager managed, you have your operating agreement says that managers can be paid for the services that they render, that managers make the decisions as to how much managers should be paid. And so you would just do a shift. Now, this is hopefully an absolute worst case scenario, and I highly recommend that you have an umbrella policy, especially if you're a real estate professional. But this is so easy. If you have a member managed LLC right now, you should change it to be a manager managed LLC and, make sure that you get an operating agreement that has the language that I am talking about, because otherwise it doesn't work. So, like I said, signed operating agreement. It's just your internal written governing document. Doesn't have to be long. It needs to cover how management and membership is handled and how people can become members. So if you've got that creditor that comes in, members don't have any authority to do certain things, and that will protect you from reverse piercing the corporate veil. And we call it, so from the top, it's piercing the corporate veil, and from underneath, it's reverse piercing the corporate veil. If you don't have an operating agreement, it doesn't matter how you were managed, and you have a creditor coming after you, you're going to have issues. All right, transferring property into your LLC. So in order for you to get any kind of limited personal liability from having, from your rental property or added protection, then it needs to be owned by the LLC. You can't just form an LLC and not transfer the real property into it. If you can purchase the property in the LLC name, you're going to have to do a personal guarantee on it, but at least it's already in the name. So if you don't have, if you're looking to put your property into an LLC, you need to transfer it from yourself personally or from your trust personally to the LLC itself. And it is critical to get the legal description right from the vesting deed. Given that this is fraught with errors, I highly recommend that you have a professional do it. If there's a mistake, insurance is going to cover it. We, in fact, at our office, literally take the description from the vesting deed and like cut it out. It's like a kindergarten project and rescan it so that we have exactly the correct legal description because it is so easy to make a mistake on it and it matters. And if you're in the real estate business, you know what I'm talking about. Those super long legal descriptions, ooh, having to retype those, very hard. All right. Also, before you go transferring property, ask your tax professional because there are always tax ramifications. All right. If you already have if you have a mortgage on your property, transferring the property into your LLC is problematic. It may trigger a due on sell clause. And what a due on sell clause is a clause in your deed of trust. We call them mortgages. They're technically not a mortgage in the true sense of the word, but look in your deed of trust. And a due on sell clause basically says if you're going to transfer this property from one person or to another, then you must pay us off. Like your entire debt is due. So think about a sale of the property. I'm going to sell my house to my friend Monica. Well, my due on sell clause says that before I can do that and pass title to Monica, I must pay off my mortgage and then she can have the title, right? So that's what a due on sell clause is. So if you transfer the property from you to your new LLC, technically that's a transfer. Now, we all know that it's just you, but it could trigger a due on sell clause. Now, some of my clients are like, okay, well, how's the mortgage company going to know? And I say, well, they're not unless you tell them. I suppose that they could go to Coconino County and look in the recorder's office and be like, oh no, that Lisa, she, she transferred her property. We're going to call the note due. But legally, you could be triggering a due on sale clause. Mortgage companies will allow you to transfer real property into a revocable trust because revocable trusts are not a separate entity, so they don't trigger the due on sell clause. If you are in a situation where you do not feel like it would be you're uncomfortable transferring the property into your LLC name because there's a mortgage, I would put the property in a trust, which is better than nothing. And go from there. And once it's paid off, then transfer it into your LLC. So the basic question is, should you own it in an LLC? So yeah, personal liability protection, awesome. You need to think about, all of this comes down to a numbers game, which I'm going to talk about in a second. But, you need to make sure that you can get insurance. It's going to be in the LLC's name. Do you need an umbrella policy? Is transferring the property going to trigger that due on sale clause? Does it matter to you? Could you pay off the mortgage if they demanded it be paid? Some of my clients are like, yeah, we could. Let's do this. And again, going to a trust might be helpful too. All right, should you own all your rental properties in separate LLCs? This is definitely a numbers game, and it's like, how risk adverse are you? So, like I said, any LLC that gets sued, the only thing that the plaintiffs could get is what that LLC owns. So, if you put all of your LLCs, let's say you have 10 and you put them all in one LLC, like all the titles are in this one LLC, if something happens on one, then the others might be in jeopardy as well. You could put each one in its own separate LLC, each property in its own separate LLC, that's fine. You could put two properties in each LLC. Because every time you have an LLC, you have to get a new EIN. You need a separate bank account. You need to do everything to keep it separate and apart. So when you get 10 LLCs, you've got 10 different things that you need to do. 10 different EINs, 10 different entities, 10 different bank accounts. Sometimes you can do, and you really want to talk to your legal professional as well as your tax professional about this, because there is no one size fits all on this. You could have one LLC either own all the other LLCs, or and deal with everything at that level. So you have one LLC and you have all the other ones underneath it. And this one is the one that makes all of the contracts, pays all of the bills, gets all of the rent, and all of it is handled here. And you could have consolidated financials. You could also make this your own property management company, so long as you're not doing unlicensed property management. Like, so again, make sure, but you could have the entity that's doing that and doesn't own these properties. So again, you might want to think about, how you can limit your administrative nightmare. Sometimes if you have just one LLC that's your umbrella, it really allows for getting some discounts. It saves on taxes a little bit, maybe. Mostly it might help you keep, your formalities intact. All right. You should also, especially when you own rental property in your LLC, have a succession plan. And basically, the reason why it's critical for, if you are a single person, you should definitely have a succession plan, because you need to make sure, what happens if you are unavailable to deal with your business, and what happens if you pass away. Because if you have heirs, or someone needs to handle the LLC itself, and you don't want to have it go into a probate necessarily, you want to make things easy for your heirs. If you don't have a succession plan, which just means what happens if you are either permanently or temporarily disabled, you could lose everything you work for. In companies where you have people who are not married in the company, you could have disputes. There's no one size fits all succession plan. There are very different ways to deal with a succession plan. This is my list of things that you could do. All right, so again, you want to think through what happens if you can't run your business. You know, do you want to have a signer on your account? Do you want to have another manager? Do you want to have something that springs in, if you're unable to do what you need to do? What happens if you die, as I mentioned? You can have the ownership of your LLC owned by joint tenants with right of survivorship. So if you have two or more humans that own it, you can say, hey, if something happens to Lisa, then Monica gets the business. And, you could have life insurance on me as a key owner, and you can have your operating agreement say the only thing that Lisa's heirs gets is, the life insurance payout, or we're going to value the business and Monica is going to pay out Lisa's heirs because she passed away. So that's one thing that could happen with joint tenancy. Community property with right of survivorship is the same for married folks. You could have your LLC owned by a trust. You do not need to have a trust. I think that trusts are overused. There needs to be a reason why you have a trust. Maybe, in my circumstance, because I'm a licensed professional, I needed to use a trust but I think you could do joint tenants with right of survivorship just as easily. If you have rental property, or if you don't have another reason to have a trust. Again, you really, really, really want to follow formalities. And here are my key takeaways. So, use your proper terminology, sign documents appropriately, have an EIN, don't commingle funds, have your written internal governing document, be manager managed for sure. Keep your public records up to date with the Arizona Corporation Commission, the Secretary of State, the Internal Revenue Service Code, the Arizona Department of Revenue, and follow your business on the Arizona Corporation Commission website. You can do that. If you don't know if your records are up to date, check them out as soon as we get done. Always have your contracts reviewed annually or biannually as you need them, and definitely have a team. If you need to reach out to us, this is our information. A lot of what I spoke about today is in our frequently asked questions, so you're welcome to go there and get some information. I also have a blog if you want to follow me where I put in tips like this. I hope that everyone has learned something. So thanks for spending some time with me this morning.